Good morning. This is cause number 2021-65807. In the interest of Jaden and Cody DeVille, all parties and witnesses, please raise your right hands to be sworn. You solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
I do.
I do.
All right, ma'am, please state your name and your relationship to the children.
Sandra DeVille, I'm the mother.
All right, counsel, your name, that representing the mother, your name and who you represent.
Nicholas Trailer, Judge. I represent respondent Sandra DeVille.
All right, sir, your name and your relationship to the children.
Todd DeVille, I'm their father.
All right, counsel.
Paulina Dion, representing respondent Todd DeVille.
All right, and representing the Attorney General of the State of Texas.
Morning, Your Honor. Kavita Sharma for the state.
We've got a motion to confirm support arrearage. What are we doing today, Ms. Sharma?
Yes, Judge. The Attorney General is non-suiting their motion to modify the child support order at this time. And I believe Mr. Nicholas Trailer, counsel for Ms. DeVille, has an answer, and he has a motion he'd like to have a hearing with before the judge regarding his attorney's fees.
That is correct, Your Honor. Pursuant to 156.005, in the answer, I basically am requesting fees from Mr. DeVille on the basis that the suit for modification of the child support was filed frivolously. Pardon me.
May I respond, Your Honor?
Yes, ma'am.
The suit was not filed frivolously. At the time we filed our cross petition on September 3rd, Mr. DeVille had received a notice from the Department of Veterans Affairs that his monthly award amount for disability had been decreased to $1841.35, and that is why we filed our cross petition seeking to reduce the child support. That is not a frivolous reason to file a modification. I'm asking the court deny the request for attorney's fees based on 156.005.
Ms. Sharma, anything to add?
Your Honor, the state has no interest in attorney's fees. We've non-suited our modification as of today, so we have no further interest in this case.
Mr.
And
Trailer,
Your Honor, we had non-suited our cross petition back in January.
all right, Mr. Trailer, anything to add or respond?
Yes, Your Honor. So in essence, well, since we're doing argument, when the case was filed, Your Honor, the discovery was propounded, and in Mr. DeVille's responses to requests for production, the material and substantial change that was relied on for the basis of the suit was that there was a diagnosis of I think it was a traumatic brain injury, as well as some issues that are related to PTSD. And in those responses to the request for disclosures, it had stated that diagnosis had occurred in March of 2021, which is incorrect. Mr. DeVille was receiving VA benefits for the exact injuries that he is now alleging form the basis of this suit back during the party's marriage in 2019. And so with that, there was no material and substantial change in the for the basis for his cross petition, which required that my client hire me to, in essence, retain me to defend the suit.
Ms. Dion?
The divorce decree is based on Mr. DeVille receiving a VA benefit of a little over $3,000. So in September, when it was reduced to almost half of that, that is a basis for modification. And the reference to the PTSD diagnosis in March is Mr. DeVille received that diagnosis from the psychiatrist at the Veterans Affairs in March.
Any
Well,
further?
Your Honor,
Go ahead.
it was, so with respect to the, the diagnosis in March of 2021, there, in the responses to requests for disclosure, Mr. DeVille states that he was part of a, I guess, a inpatient and outpatient rehabilitation program, and that's where he received the diagnosis. But again, Your Honor, in
No.
2019 is when he had the diagnosis of the post-traumatic stress disorder as well as the traumatic brain injury. In his, actually in 2017, Mr. DeVille sent a application alleging that he had sustained those injuries at that time period. And then the VA treatment program was not, I mean, Your Honor, it is my opinion and that it is not related to the PTSD or the post-traumatic, or excuse me, the traumatic brain injury. And that's because it stems from a criminal action in Montgomery County where he was had the option to either go through the judicial process or through the Department of Veteran Affairs, I guess the court system that they have with respect to some arrests that Mr. DeVille had. And then at the time that Mr. DeVille had filed his cross petition that was requesting that the child support be lowered in January, and I think Miss Donna had said that that was filed sometime in September of 2021. Well, on January 10th of 2022, the gross benefit that Mr. DeVille was receiving was $3,666.94. And so the fact that it goes up after they filed their cross petition, it's nonsensical that can formulate the basis for a modification for a reduction in Mr. DeVille's monthly child support obligations.
Your Honor, the basis for our request for a modification has nothing to do with when Mr. DeVille was diagnosed with PTSD in 2019 or 2021 or whatever. The basis is that on September 4th, 2021, and opposing counsel has this document, his monthly benefit from Veterans Affairs was reduced to $1,841.35. And so we filed the requested modification on September 3rd, our cross petition on September 3rd. Then when he received a new letter on January 10th that his benefit amount had gone back up, we immediately non-suited on January 24th. So again, under 156.005, Mr. DeVille's request for a modification was not a frivolous filing, and the request for attorney's fees should be denied.
All right, the case is dismissed and father's attorney's request for attorney's fee is denied. Thank you.
Thank you, Your Honor.